Clear, sir?
Yeah. Thank you.
Yes, we can start, sir.
I thought it's 4:30 or we can start now itself, whichever way.
It says 4:15, man.
Okay. Shall I start? Oh,
Yes, please, sir. More
yeah.
than 250 participants have joined.
Okay. Yeah. The the topic of the exam is leading cases. What I will do is I'll give a brief introduction of what personally what I think from the past exam question papers, etc. Explain briefly what we are expecting in the leading cases, the understanding of the one, and then take you to some of the illustrations. The leading cases by itself suggest these cases lay down some principles which becomes necessary to be which it becomes relevant for following in the subsequent cases. More importantly, for the courts, etc., it becomes a law for the principles which has been laid down. Therefore, when you attempt these kind of questions on the leading cases, the first and the foremost, it would be very useful if you know what was the position before when you're reading the cases and what the case has done and what the position which has been followed in the cases. I'll give an example, one or two, which would be of help. All the cases you have, are either coming from an impugned order or Article 32 petition. There will be a rival contentions, issues will be there. The courts go through the process of analyzing the law, then gives a conclusion which is more importantly the principle which they are laid down, not the facts of the case as much. The principle laid down becomes very important for you to determine it. When you are examining either the constitution or the law, the first and the foremost is what was the objective of that provision. If you keep the objective of the provision in mind and then read the provision and the provision, you will understand what it intends to do or what mischief it intends to avoid or what provision it makes for a direction, etc. The courts are interpreting it. And if you get the sense of what the provision, what the right and wrong which the provision wants to deal with it, probably you will be in a much better position to understand the case and go. What is necessary to call out the principle, and if you understand the principle and then attend the questions, etc., it will be very useful for you. And then what you personally feel also, don't go by what the judgment has done is a gospel truth. If you may have some other views on the judgment, if it is rational, in my personal opinion, you can even express that. On some of the cases may require some kind of a consideration different than what the courts have decided. That would also can be attempted, although normally people follow whatever the courts have decided. Just move to some kind of an examples, few examples of it. Like when you're dealing with an important case like Keshwanand Bharati's case, which deals with the basic structure of the constitution, and the analysis done, it's a very long judgment, but you may be aware of the analysis which has done, and more importantly, how that decision in the Keshwanand Bharati's case has moved on from that case to other cases like Maneka Gandhi, the Minerva Mills, and going on even right up to the recent decisions, which are some of these decisions are already forming part of that 64 cases which has been given along with the list one. That tracing of the development of the principle which was laid down on the basic structure, how it moved from the thing to Minerva Mills, where there is an excellent description of yeah, majority decision and the minority decision, which will give you the rival points which are considered, and thereafter in Coelho case and other cases, how it has been dealt. That kind of an analysis would be very relevant for answering these kind of questions which may come before you in the examination, if it comes before you in the examination. In particular, if you can go on the decision making process there, how the courts have analyzed it and why they have said what is the basic structure of constitution. And you let also remember that they are not merely dealing with the fundamental rights and the directive principle. This basic structure of the constitution has been evolved over a period for even things other than the fundamental rights and directive principle. It moves to ninth schedule, insertion, and all those things. Those are as a process. If you can analyze it and do it, that would be very relevant for the day. Then there are areas where very important issues have been considered by the Honorable Supreme Court from time to time, like the question of whether can the court legislate on matters which is reserved for the separation of powers to the legislature, the parliament, etc. And there are cases which have gone into that issues, like the Ashwini Kumar case, D.K. Basu's case, and they have also noted the limitation on the separation of power. It's used as a kind of important where it becomes extremely necessary to legislate. And power to legislate is with the legislature. The court do not generally do legislation. The court only recommends sometime framing of legislation. That mix-up should not be there. The court, by legislating itself in the judgment, is different than they merely recommend it. Up to a number of times the courts have said it would be better for the government to enact a law. They may even observe what their recommendations are, but the parliament is not bound by it. Those distinctions will have to be seen in these cases like Ashwini Kumar case, D.K. Basu case, and Vishaka case, and the Common Cause case, which have dealt with it. Some of them did provide in a mandatory form a legislation to be followed. Those kind of issues, you can consider that also. Then if the another area where an important jurisdiction of the Honorable Supreme Court has been extended is the curative petition. The curative petitions have been considered in the later part of the past 10 years or so, and an important decision in this connection has been given in the Rupa Horas case, which is included in the list of the 62 cases. And the analysis of the Rupa Horas case, whether it's an exceptional circumstances only the curative petition is due. What is the components of or the ingredients which has to be done for exercise of, like, manifest injustice, miscarriage of justice, abuse of the process, etc. And there are a number of preconditions for exercise of this jurisdiction. And what is the nature of this jurisdiction? It's almost like a second review of the case decided by the court, where the review petition has been dismissed on account in limine, in chamber, without being listed in an open hearing. Like if a case gets listed in a review petition on an open hearing, thereafter, as far as the law stands today, there is no curative petitions which is maintainable, and that is a precondition. Apart from conditions like a senior advocate will have to give a certified. The questions cannot be raised. Fresh questions cannot be raised. Whatever you have raised it in the thing. And this curative petition is also evolving. So far, they have done it in an exceptional cases of where there is a miscarriage of individuals, etc., or some kind of an extreme cases. There is an instance of this jurisdiction being exercised even in commercial matters, and in the recent past, those issues may also be relevant for you to take into the other areas where the courts have gone into is contractual issues, and the court's jurisdiction to vary the contract, particularly in the context of the infrastructure and regulatory jurisdiction which are coming, whether the infrastructure laws permits the regulator to change the contract terms, etc. The courts have gone into. Generally, a contract is being a volition between the two parties. Courts do not create a contract or a substituted contract, and they follow the contractual sphere follows what the interpretation of the contract only. The intention of the parties is not changed. The dominant thing is what the parties intended the contract to be, howsoever unfair it may be, unless in extreme case of dominance and exploitation, etc. They do not, like Minimum Wages Act has come to vary some of the contracts, etc. Otherwise, in commercial contracts, they do not. And this has also been gone into in some of the cases which is provided, like MCO case, Gujarat Urja Vikas Nigam, and MCO cases. And another important aspects of development for the long time is on the section 63 and 73 and 74 of the Indian Contract Act in the sphere of liquidated damages and proof of damages. And there's always been an argument saying that the liquidated damages does not require a proof. The opposite argument has been the liquidated damages is only a cap on the damages, but you will have to prove the actual damages. No damages could be given unless there is a proof of the actual loss suffered by them. This aspect has been considered in Kailashnath by Justice Nariman in detail. Justice Nariman's judgment refers to the previous case laws and previous case laws and concludes in a particular paragraph the principles. Even that principle has been interpreted subsequently. The question is under what circumstances you can say that in spite of the liquidated damages has been paid, and even if this liquidated damages is not in the nature of a penalty, it cannot be considered, but still the proof of actual damages is necessary. That particular Kailashnath decision deals in gist with the previous cases, which has then dealt with both sides and then laid down the principle, and subsequently it has been followed. In my personal opinion, when you are writing this kind of an answer of any particular decision, it is always better for you to analyze further and see what kind of further case laws have come and add it. That will add value to your answer. One. The another area which has come in detail examination is the Insolvency and Bankruptcy Code, and there are a number of decisions. Two of them are given in that list of the 64 cases, the SR Power as well as Swiss Challenge. These cases lays down how in a resolution process the committee of creditors decides on many things. The Honorable Supreme Court has now so far has held in these two cases that once the committee of creditors have decided it, including on the value at which the property will be handed over or the company will be handed over to the new person who is giving the resolution plan, then that is the end of the consideration. After that, there will be no consideration. And more importantly, what happens in these kind of cases is under section 30 of the IBC code, the Insolvency and Bankruptcy Code, the committee of creditor decides by a majority. If there are, say, 5 lenders who are the financial creditors, they by majority in value, 75% of the value, decides that this company should be given to the third party with under the resolution plan, and they take some amount of haircut and their dues, then the amount which is realized is less than what is owed to the financial creditors itself, then almost all the other creditors gets wiped out, subject to some statutory dues, employees thing. Other unsecured creditor, other non-financial creditor do not get any amount at all. Many of the unsecured creditors have lost a lot of money on this one, and it is almost the resolution process has been interpreted akin to a liquidation process where there is a priority of claim, etc. Here the company is continuing to run, but by a third party. He gives X amount of money, takes the company away. That money is absorbed or completely appropriated by the 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 financial creditors, leading to all people who have dealt with the company, incurred expenditure, have money due from the company to them, they do not recover anything. This aspect is again agitating at different levels. At some point of time, some decision will have to come as to whether this would be fair or not fair to treat a resolution process implication equivalent to a liquidation process. That also is an important aspect of the decisions which has come and which has to be further done. The recent decision of the Honorable Supreme Court in the cryptocurrency matter is also gone into very great detail of how the power of the Reserve Bank of India is there in regard to the currency matters. That may also be of relevance when you are studying how they have analyzed it, why the provisions of the Reserve Bank of India's Act has been held to be constitutional and valid, and it is not a colorable legislation. They upheld the issue of the cryptocurrency or the new coin currency, etc., in a particular manner. How far what is the issue, etc., of that issue by the Reserve Bank of India has been allowed, but not by the others, etc., which have to be heard. And this has been tested under Article 19(1)(g) of the Constitution. How those things will have to be considered. The another area which is important is on the arbitration, section 34, and there are volumes of cases decided on section 34. After the Arbitration and Conciliation Act 1996 was enacted, the term public policy, opposed to public policy, which is a ground for setting aside the award, has come in for number of discussions from time to time. Sometimes read in a restrictive manner, sometimes read in an extensive liberal manner also, and anything opposed to the conscience also sometimes has been read as a public policy. Infraction of any law has been read as a public policy. All these have led to a recent decision in Sangyon engineering case, where they've gone into again this detail referring to all the past cases, and how they have dealt with it may also be very relevant in considering section 34, including the amendment made in section 34 by bringing patent illegality or illegality as a ground for setting aside the apart from this, I would also say that there are issues on right of the right to life, which has been considered by the Honorable Supreme Court, and in an extensive judgments have been given. It's a very difficult area for people to get into, for people to analyze the one. But some exception, very, very extreme exception has been now carved out, and saying that you can, in that kind of a situation, you can be permitted to end your life, or give direction for allowing your life to be ended through a will or something like that. That would be also relevant for you to consider the one. Then, apart from that, there are issues on anticipatory bail. The recent decision on Sushila Agrawal's case have gone into extensively on these kind of issues, where the anticipatory, we have clear guidelines have been granted, given where the anticipatory bail will be considered or not considered, etc. A good directions have been given on consideration by the other courts on the anticipatory bail. That would also be one. And similarly for life imprisonment also, now the directions have come in Sriharan case, which is part of the list. Again, what kind of where the life imprisonment, what do you mean by the life imprisonment? And also a separate superior special category of life imprisonment has also been considered. On the overall attending the paper, I would submit that you should you should you should, as far as possible, analyze in your own language. You don't have to repeat what the exact sentences in the judgments, etc. Analyze in your own language, and the logic or rationale of your submissions would be a good way of looking at it, of your perception of the concepts decided in the cases. Speaking for myself, I do not think it is necessary for you to remember the sections, etc., by heart. What is important is have the concept of what has been decided can be deduced from the answer. That would be the relevant consideration for evaluating the exams which you have written. I would not be able to tell you into the specific cases more than that. That would not be the thing. But if you see the list of the 64 cases, many of those cases are interrelated. You will find out it's not really 64 cases. It can be grouped like I have done it for you in a sample way. It can be grouped, and if you can read it on that basis of a group, probably you will get a better idea of what these cases. Again, I would emphasize that development, since it's being leading cases, how far it has led the development is much more important. You will have to see how the cases have traveled from time to time, how the it has been expanded, it has given new dimensions to it, all those things. You have come across like IBC changing the whole concept of contract entered into between the parties, saying that the committee of creditors would decide what is the purpose and the objective to salvage the industry. If it is to be salvage the industry, how far you can take away the right of the creditors to receive money in a running business. Can you say the business can run, but at the same time you will not be paid? All those aspects which have to be which is necessary for you to consider. And if there is any general thing, if you can put it in the chat box, I can explain it, but not a specific question on things. Someone has asked about the options in the paper. There will definitely be. The proposal is to give the options. Probably the option will be equal number of questions, twice the number of questions which you'll have to answer. But these things will have to be decided finally. I'm not the master of that one. And the proposal is that if it is X number of questions to be answered, that will be 2X question for you to make a choice and do it. The IBC, the important cases is already indicated in the list. It is the SR Steel matter, which get into the ArcelorMittal case, and the Swiss challenge matter. These are the two important cases. But on the same line, if you see further cases decided, it will give you the subsequent development also. Justice M.R. Shah has also given some judgments after this one, and you can analyze it. There are some judgments of NCLAT which has come afterwards, which have gone into the same issues. But the two leading cases which has been given is already there in the one. One is the SR Power case and the. I have gone by the 64 cases, and I do not find the reservation case. I would suggest that I'll put these things to the one Mr. Nikhil Nair is going to take the another class. If there is any development, he will be able to do that. But it's not there in the whether one should deal with the dissent view. I would say that if there is a good analysis of law giving the rival view, it may be better to put the dissent view also. But normally you should go by what the majority decisions are. The decisions are. I would say that like you, if you see the Minerva Mills case, there is a very good discussions by the dissent view also, and also the majority decision. You can even comment upon why some of the aspects in the dissent view appeals to you, or what is the reason or rationale for that one. I'm sorry, I'm reading it and speaking for myself, there is no, I would not go by the length of the paper, length of the answers, but something to indicate that the conceptualization by you is giving complete indication of the concept having been agreed, has been analyzed by you, and that has come out well. It's not that you have to repeat number of things or cite number of authorities. So in your answers, what is necessary is whether you have understood the concept of what has been decided. You can even combine 5 judgments in your mind to put the concept and put the summary. That would also. Yes. Common cause, the right to life case is what has been decided in the common cause judgment, 2018 judgment of Justice Chandrachud writing. It's there, item number. I'll just give you the item number. 44, sorry, 44. That's a union, common cause versus union of debt.
Someone seems to have lost the Kailashnath portion. Your voice was not heard.
The Kailash, somebody has asked for what was there in the Kailashnath because the voice was not audible. The Kailashnath case was deciding the issue whether if the contract provides for a liquidated damages, is it necessary to still prove the actual damages? To explain it, suppose the contract says that in case the contract is broken, there is a breach of the contract, you will pay X amount as liquidated damages. One view has been before Kailashnath, or even it's dealt in the Kailashnath, is that that is not sufficient. You have to prove the actual loss. Suppose you are not able to prove the actual loss, then no damages can be given to you, although the liquidated damages is provided for. It is based on the concept that the contract may be broken unless you suffer loss, you will not be paid the damages. That is the view under section 73, but 74 of the Contract Act deals with the liquidated damages. If you see the judgments, various judgments cited in the Kailashnath's case, like ONGC or a BSNL cases, there the view taken appears to be saying that no, once you put the liquidated damages, then you do not have to prove the actual loss unless the liquidated damages is put in an exorbitant manner, what they call in terrorum, to terrorize or to exploit. Unless that is there, the liquidated damages does not require a proof. There are other judgments there which indicates that the proof may be required. Para 43 of that particular judgment puts the categories. The analysis of that category 43, 1, 2, 3, 4, etc. is what is most crucial for this particular kind of a cases. And these have been analyzed in subsequent judgments of the Honorable Supreme Court as well as by the Honorable High Court. Those makes a very interesting reading. because it traces back to the old cases of Fateh Chand, etc., Mullah Bags, etc. Therefore, the entire history will be available. And this aspect comes again and again and again in contractual matter. What is the point in putting a liquidated damages if I have to prove the actual damages? By putting the liquidated damages, you are putting a cap on the actual damages also. Suppose the actual damages is more than liquidated damages. In that case, you will not be, by putting the liquidated damages, you will not recover it. But at the same time, you have to prove. This may be a very interesting way of looking at it if you analyze all those case laws.
And reasons.
Can you give the opinion and reasoning? I personally think that you should give the opinion and reasoning. That's what the examination, according to me, is to test the caliber of the person, whether he can put the rational and reasoning, or at least, if not a complete reasoning, it will be useful if some part of the reasoning in the judgment, if which is not to your rational mind correct, it's better to at least indicate that kind of a one. But but it should not be simply a vague kind of a thing that this reasoning is not there. You have to support it by your own reasoning or rational.
Cases on amendment. List of cases that you.
No, the 368 cases, say, it may not be fair for me to say go outside the basic cases, etc., with the other cases, unless you deal with the basic cases. And the basic cases, we have given it in the 64 items, starting from Keshnamati, Manaka Gandhi, Minerva Mills, Subhash, Dr. Subhash Agrawal case, etc. We have given it. But once you have dealt with that one, with these cases, better to, if you can add it, it's okay. But I won't be able to tell you to say you should sorry, you should necessarily go out of these 64 cases. That may not be fair to the other people writing the exams. Yeah. Yes, when you are dealing with the RBI case, the rationale of using the MS Gill case has been dealt with it. You'll have to understand that one and put it. I should not be telling you what further rationale has to be done. It is already referred to. MS Gill case has been referred to in the RBI case. You can, if in your view, if common cause judgment on right to life has overruled any part of Aruna Schonberg, you should mention what your opinion is, or whether the common cause judgment has expanded the area of consideration of the one. If you come to the common cause judgment also, the fifth exception is the only thing they are allowing it. Therefore, to that extent, whether it's a modification or one, and you'll also see that Aruna Schonberg case was decided more on the facts of that particular case. That need to be the consent cannot be given by the person who is wanting to put his life to an end. The change in contract judgment is referred to is the Gujarat Urja versus MCO Limited in the context of infrastructure, electricity, where after the contract has been signed, implemented, whether a regulatory commission can put additional condition or change the nature of the contract or change the substance of the contract. MCO decision itself will give you a lot of other decisions which is there, and also the principle whether court can create a new contract if court cannot create a new contract, but in an infrastructure regulatory jurisdiction, can a regulator create a new contract? That has been put. Oh, sorry. The name of the RBI case is the Internet and Mobile Association, which is item number 62. If you want to cite more cases beyond the 64 on a question which is relevant to the 64 which has come before you, you're most welcome to do that one. That gives a good in-depth knowledge of what is happening subsequent to it. But there may not be I do not think there will be a question outside the 64. The paucity of time how to go about 64 judgment is a judgment which you have to make it. I don't think I can do that one. I don't think I would personally say that the reading may not be difficult, if not the entire 64. Like if you see that one, you can group it and read it. Out of the 64 judgment, 5 to 6 judgments are under the amendment to the Constitution, 368, etc. Yeah. Life imprisonment case is the Sriharan case, item number 37. That's a life imprisonment case. How to approach Keshwananda Bharati? Nobody is asking anybody to see the whole volume of Keshwananda Bharati. You probably, if you start the reverse way by reading the Maneka Gandhi, Minerva Mills, Subhash Agrawal, etc., you will get the gist of the Keshwananda Bharati's case. Nobody at this short time available for your. I don't think many lawyers would have read the Keshwananda Bharati's case completely. But you can easily understand from the subsequent judges what the Keshwananda Bharati did and how the things have developed afterwards. It depends. Do you need to write the facts of the case? It depends upon it. It depends upon the question. I believe that mostly the facts will be very simple to write or may not be required to be written, depending upon the nature of the questions. The questions will be, if at all, if it is factual basis, you will get the facts in the question itself to deal with that one. We are dealing with leading cases which are not really case specific, but that doesn't mean that you should not give the facts, because for understanding the rationale and the ratio of the judgment, sometimes it may be better to deal with what the facts of that particular case. Somebody asked MCO case, Gujarat Urja Vikas versus MCO, item 38 of the list. After Rupa Hora, there was a case of a commercial, but it's not a reported case. That's why. But there, the curative petition was admitted in a commercial matter, but it was settled between the parties of the thing, and therefore it did not go further. Therefore, I won't say that whether it has been authoritatively held, it would be applicable to commercial matter or not. That may not be there. But what I would suggest is if you read the Rupa era, particularly paragraph 49 onwards, where they themselves say that the list of areas where curative petition is not exhaustive, they have listed some illustration, but coupled with the fact that it should be extreme cases, abuse of process, manifest injustice, that level at which the curative is entertained is very high, very exceptional. Yes, all deal with the right of the right of the Honorable Supreme Court to legislate. Right of the those are the the common thing between Visakha, DK Basu, and 2008 a common cause, and as well as one more case, for all that whether the whether the Supreme Court, the judicial wing of the country can legislate that one. Very interesting reading, particularly the last case of common cause, where last case of Ashwini Kumar, where serial number 54, where they have brought back the separation of power and how should not be done unless in an exceptional, very exceptional case. I see. I may not be able to answer which case is important or not. The list of cases has been given. I've given an indication of what kind of a grouping can be done. It would not be proper for me to say whether any particular case is important or not important. But as you said, there will be, there's in all probability there will be a choice. It's not a compulsorily writing all the thing unless there is a change, which is most unlikely, if I may say so. See, you're again asking for the length of the answer. Speaking for myself, the length of the answer may not be, if you are able to precisely put the answer in relation to the concept and concept is understood, the length may not be met. It may not also be say 8 questions to be answered, etc. It will be less than that. Therefore, you will have at least the indication given to me is that it will be sufficient time for answering the questions. The decision as to how to start and how to conclude, etc., you are the masters. Each one has his own way. You can do that one. As I said, the analysis of the issue leading to the conclusion that you have understood the concept is most important.
Item 50.
Yes. Item 57, Committee of Creditors of SR Steel is insolvency. It has to be read along with the Sanglian case. Sixth ribbon case, sorry. Sixth ribbon case. 52, along with 52. That's it. I made a mistake. I hope this has been helpful to you. Hopefully it has been helpful to you. There will be one more lecture by Nikhil Nayak. I think 8th or so, if I remember correctly. Oh, thank you. Thank you very much.
Thank you, sir.
Thank you.